The Supreme Court has on Thursday adjourned the hearing of suit filed by Nnamdi Kanu, leader of the Indigenous Peoples of Biafra, to September 14. It will be recalled that Kanu had approached the court to appeal the verdict of the appeal court stopping his release from the Department of State Service custody. On October 28, 2022, the Court of Appeal granted a stay of execution on the verdict which discharged Kanu of terrorism charges filed against him by federal government. In a unanimous decision by three-member panel led by Haruna Tassamani, the appeal court granted the application filed by federal government pending the hearing and determination of the appeal court before Supreme Court. Kanu has been facing 15 counts of charges bordered on treasonable felony and terrorism instituted against him at the Federal High Court by the federal government. He was rearrested in 2021 in Kenya for inciting public violence through radio and television broadcast and defaming Nigeria's authority through broadcast. On April 8, 2022, Binta Nyako, a federal high court judge in Abuja, struck out 8 out of the 15 counts in the charge. The Court of Appeal later quashed the remaining 7 counts on October 13th. During court proceedings on Thursday, the Supreme Court granted the application of Abba Kamalani, Attorney General of the Federation, to file additional processes in response to Kanu filing. The Apex Court said even if it proceeds to hear the appeal, there is no space within its calendar to write and deliver the verdict within 19-day deadline. The case was therefore adjourned to September 14. The pro-Biafra agitator's lawyer is also seeking bail and transfer of his client from the custody of the Department of State Services to Kuje Correctional Facility so as to get proper medical attention. Addressing journalists after the court section, the lawyer to IPOB leader Mike Ezekome said,
"So from all intents and purposes, the appeal was ripe for hearing. But today, the federal government came and said they wanted to file a reply brief. I told their counsel, you can even, these points of law you are showing me which you want to file formally, you can stand up and say them orally, verbally, and we will not oppose. In any event, you are saying we raised a preliminary objection in our brief. It was raised in our brief, not as a separate document. But I believe that their own intention was to stall the proceedings because he said he had the instruction of the Attorney General that he must reply to it. I said, no one is saying you should not reply. But it doesn't have to be in a written form. You can reply orally. We have all done it now and again by replying orally, verbally. He will not do that. So the Supreme Court said, in order not to show them out, they will give them a short time to file the reply within 2 days. Then I begged the Supreme Court, I pleaded with the Supreme Court to give us the shortest possible date, even this month or early next month. But they looked at their calendar and their docket that is pitiably full. It's so unfortunate this is the busiest Supreme Court in the world because all manners of cases come here and politicians will fight themselves dirty and they will all end up here. They looked at their dockets and discovered that the next available date is after the vacation, which will be 14th of September.